All rise for a pledge allegiance. Pledge allegiance to the flag of the United States and to the republic for which it stands, one nation, under God, indivisible. Thank you all for coming. It's been the biggest crowd we've had in a while. See no emergency services. So we'll do announcements and then we're going to bounce around a little bit with this, with the agenda today, as we've got some people here that's got some presentations to do. So bear with me as we go through. We're going to bounce around from some of the zoning hearing board stuff and some of the regular agenda items. So we're going to start with announcements. I guess we have a little bit of an update on the aerial seating incident that happened a while back on Hollowhorn Road. We did contact all of the parties involved in that, and we were told that it was only a plain dispersing rice seed and there was no it was not encapsulated with anything. And we had some samples brought to the township and the team to confirm that. There was no evidence of a second plane distributing chemicals or herbicides, and the town has formally requests that a notice be given in any future aerial agricultural activities, so we could let everybody know before that happens next time. The office has also completed the E360 general code project earlier than projected. The general code will be providing an ordinance in the near future for consideration by the board and the solicitor to prepare for adoption that includes not only the zoning, but the subdivisions and land development. And once adopted, this project will provide a clear searchable database for use by the public as well as the township in a format that will make review process much more efficient and easily updated when necessary. So this will be an online version of all of our zoning and codes, which we've got the codification done, and this is the translating it to a digital format we could then put on the website. So shortly. The town has also hired June Rapinski to take over bookkeeping activities for Tinicum Township as a 1099 employee for now, being that Terry is leaving here as of Friday. So we do have a bookkeeper that we did hire. Yeah.
Actually, you're making a motion to hire her.
I'm making a motion. Okay, so I guess we've got to I'll make that motion.
I'll second. And it's to engage June Raspinski as a 1099 independent contractor.
All in favor?
Aye.
In the land, last announcement, the Land Preservation Committee has updated the open space booklet, and copies are available over there on the credenza. And thank you everyone for putting that together. It looks really good. I guess just the last announcement, as I just said, Terry's last day will be Friday. Again, we thank you for your service to the township over all these many years, and wish you the best going forward. And also, Joan Tanner, who has also been an assistant here at the township, her last day is tomorrow at the township, and she's probably talked to a lot of you if you ever called to the township, and she's formally retiring. So we wish both of you the best, and thank you for all the years that you've put in here and helped the township.
For the 27 years.
I actually want to thank the board, Steve, and the residents for you're all been wonderful to work with, and I've gained a lot of experience. I've gained a lot of friends, a lot of knowledge because of you, and so don't be strangers. I can't keep going because I'm going to cry. Thank you all.
Okay, so on with the meeting, I'm going to go to old business, the headquarters road bridge, and then I'm going to jump into one of our zoning hearing board discussions, because we have looks like we have a little bit of a presentation here, and some people are waiting for that. So we could go on the old business headquarters road bridge update. From last meeting, we don't have really much of an update. We still haven't been in contact with the group who is giving us some funds to investigate doing a rehab of the bridge. We've yet to have those continued discussions after we've got the report. And from the standpoint of the bridge with PennDOT and the ongoing litigation, there are still 4 pending, and they are still working their way through the process through various appeals. And Steve, I guess maybe you could give a little bit more of an update on that, but basically they're all still working their way through the process. with
Yeah, the,
a decent time frame related to all of them.
yes, with regard to the, federal lawsuit, the mediation has been terminated, and I understand that there's going to be a request for reconsideration based on, the report that Doug Bond submitted. The Environmental Hearing Board hearing has been held, and post-trial briefs, are due, after the transcript, is filed, and, it was estimated that briefing would be completed probably in February, and that probably means a decision in that case sometime in late spring or summer. The action to quiet title, it had been filed, was dismissed, on the basis, that it was moot, and an appeal, has been filed from that, and it's fully briefed, and there'll be, no doubt an argument scheduled. Again, I wouldn't expect anything in that before next summer. And, the preliminary objections to the declaration of taking filed by the, Commonwealth, were dismissed, and that's been appealed as well. So all of those cases are still, pending.
I guess at this point, I'd open the floor to the public. Anyone has a comment on headquarters road bridge items? Yes.
So my name is Valerie Bellapina. Oops, and I'm sorry, and I thank you very much for accommodating me, because this is a challenge. And I don't know if everybody can hear me, but I usually talk pretty loud, so I'll work it in. Anyway, I don't completely agree, Mr. Harris, with your saying that it's still open. So I've come here tonight because of the stuff I've been hearing about these lawsuits. I've lived in Tinicum Township for going on 24 years. For more than half of that time, this bridge has been closed because 2 landowners don't want it open. Now, I want to make 2 observations, give you my perspective, and make a request of the board. So my 2 observations are this. I have read everything in this pleadings. I've read the decisions of the government. The judges. I've read all the pleadings. I've listened to most of the hearing board. And what I've concluded, and what I think any lawyer that looks at it will conclude, is that the people who built that bridge in the 1800s built it so that it interfered with the natural flow of the creek. The bridge that PennDOT wants to build restores the natural flow of the creek. I thought this was all about the environment. Maybe it's not all about the environment, because to me, that answers the question right there. The new bridge is better for the creek. 1. My second observation is they're appealing and filing lawsuits or appeals to lawsuits that are frivolous. And I want to read you, because I don't know this by heart, I will read you the Code of Conduct for Professional Ethics of Lawyers in Pennsylvania. So bear with me while I read this. A lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in a lawyer's personal business and personal affairs. The lawyer should use the law's procedure only for legitimate purposes and not harass or intimidate others. I underline that. A lawyer should demonstrate respect for our legal system and for those who serve it, including judges, other lawyers, and public officials. When it is a lawyer's duty, or while it is a lawyer's duty when necessary, to challenge the rectitude of an official action, it is also a lawyer's duty to uphold the legal process. It is my opinion that the lawyers for the Wood Tiger Fund and the lawyers for the Riverkeeper Network and the lawyers for Mr. Ginnemal have violated this professional code of ethical conduct for lawyers in Pennsylvania. The first lawsuit was dismissed with prejudice. What did? They didn't file an appeal. They waited for the appellate time to run out, and they filed another almost identical case in the same Eastern District of Pennsylvania. That's misconduct right there, in my opinion. They stood up in front of a judge and accused my neighbor, Tim Cashman, of being somehow in the pocket of PennDOT for some unknown reason. That's preposterous. It's also defamation. That's going to be Tim's issue. I'm just pointing it out right now. So these are not accurate lawsuits. There's a lot of misrepresentation in these lawsuits, and they're frivolous. The one that they are appealing, sir, Mr. Harris, has no chance of winning. The judge's decision, and you've read it, Eleanor, I know you have, because we've talked about it. These appellate filings are frivolous, and I'm asking the board to make a motion to consider having Mr. Harris file a complaint with the Pennsylvania Code of Conduct, the Pennsylvania Board of the Supreme Court of Pennsylvania, overseeing Pennsylvania lawyers, challenging the lawyers' misconduct. Because these cases don't get appealed by people. They get appealed by a lawyer who writes it up. And frankly, I have never seen such misconduct on behalf of law firms in my career. I am a lawyer. I have been one for many, many years, and I really have never seen anything like this. And frankly, I'm tired of being held hostage by a bunch of lawyers and rich people who have no real interest in this. I didn't ask for applause, but thank you. And I will tell you this. I would like to know by the next meeting, if Mr. Harris, if you think, and the board can consult with you about filing a motion to hire a lawyer to file a ethics complaint with the Board of Governors of the Pennsylvania Bar Association. And you guys can write that up the way you need to do legally to make it a good motion. But that is my request. And I would like by the next meeting to have an update on your thoughts on that. The only way a non-party has any way of expressing any interest or getting their thoughts across is by taking any other legal means. That's the one I'm recommending. The fact that they did not uphold the legal process, they took a case, instead of appealing it, they just filed another case with a different judge in the same district. Can't do that. They did it and nobody gave them any comment about it. Anyway, so I'm done. That's all I have to say. Thank you so much for giving me the time to say. And I know I'm one of those Hill people, and I know that people say F us, but this is enough. Enough is enough. I plan on living the rest of my good life. And I want to know that I'm going to have a safe bridge, that emergency services are going to be able to get to me, that I'm going to be able to get out to what I need. I'm very disabled. I'm getting a little emotional about this, and I'm sorry, but this is 12 years. It's ridiculous. Come on, you guys. Let's stand up and do something about it. Let's get on the offensive. I am tired of this. That's all I got to say. Thank you. And I'm sorry, but I really can't. I'll stay for a little bit of the discussion, but then I do have to run.
Never stay long. Hi, I'm the aforementioned Mr. Getable, and
I'm Mr. Goodall. You're my neighbor.
where really, where are you?
I live up the hill. I'm one of those hill people.
Oh, you're not my, you're one of the hill people. Okay, but you're not my direct neighbor, right?
No,
You're
okay.
a neighbor.
All right.
Along neighbors.
All right, let's keep, hey, I'll close the meeting if we don't keep everything towards here. And just as a note, Steve, I know you've talked a lot. You might differ with some opinions of what was just said, but please just keep everything respectful.
Well, I started off pretty nice. I mean, so don't
Yep, I'm
jump
just,
ahead, right? So-
I'm just, as a note to anyone who's gonna make a comment, just please keep it towards us. Please keep it respectful and to your opinion.
I mean, the Hill people is sort of a joke now, right? I mean, we just kind of,
Understood, understood.
Yeah, okay, then I'm sorry if that offends you, but let's get to the substance of what she's saying, okay? And what, Bellapina. Val, your first name is Valley, right? And then Bellapina, so I can say Miss Bellapina. Mrs. Bellapina, I'm actually more familiar with Italian last names, so that's good, okay. Mrs. Bellapina. So, and I'm glad so many people are here today. Now I understand why so many people are here. Because there are a lot of misconceptions. Okay, first off, I'm not trying to keep first, let me start around and back up. It's been 12 years and I've been involved for 2. Okay, so whatever the first 10 years are, I'm not going to address those because there's enough going on with the last 2. Okay, so I mean, I would differ with some of the issues on the Riverkeeper and certainly the Wood Tiger Fund, but meaning your comments, but I'm not going to defend them here. I'm going to defend my actions. Okay. All right. So first, and ultimately, look, I know she thinks it's all under, that these are moot. We're going to win, and people in the room need to understand that we're going to win on the property issue. There was an easement. We have no doubt that we're going to win, and there's new facts. So whatever. So basically when we win that, the entire permit process that has been filed for the last 3 years, 2 to 3 years, will be eviscerated because PennDOT moved forward with a lie. The Mrs. Bellapina said, talked about code of conduct. I intend, and my attorneys are they're willing to, they think I'm a nut on a lot of things, but this one, they're not, think I'm so crazy about. We intend to go after a couple of the PennDOT attorneys and get them disbarred. Forget about an ethics complaint. They're going to be removed from the bar. Nah, my lawyers you don't have a chance on that.
All right, Steve, could you do me a
All right.
favor
You've got the director of
address?
Commerce.
Okay.
address us, please?
You can get them to file the complaint. Steve Harris isn't gonna file it because he knows he's gonna lose it. And again, if you file a frivolous complaint against somebody and you lose it, we'll be right back at you, right? So the code said, the statute, Pennsylvania statute says you have 90 days to file when you purchase an easement, you have 90 days to record it. Okay. If you've done your legal work, you saw that they purchased, and you've read our documents, they purchased it in January 15th. I used to know days by heart. I think it was January 17, 2020. When I went into contract in June of 2020, which was more than 90 days later, I had no knowledge of this. And that's been approved by several courts. They say I have a bona fide non-knowledgeable buyer. Okay. So then so I recorded my deed without any trouble on August 8th, 2020, 14 or 20 days after we closed. PennDOT had the nerve to file their easement, finally record their deed on September 30th, 2020, almost 9 months after they purchased it. Now, why did they leave it open for 9 months? Because they probably wanted some other land. They wanted to do some other things. They had reasons to doing it despite sheer incompetence, right? Because they have 14 lawyers on this thing, right? So you can shake your head all you want, but the code, if you read the statute as an attorney, you would know 90 days means 90 days, not 9 months, right? So we're going to win on that. Now, in fact, we did win on that on April 24th. We did win on April 24th. And then it was reversed the next day. And you tell me how, right? I know exactly how. Somebody got tapped on the shoulder and said, yeah, yeah, that's exactly what happened. All right, but it doesn't matter. It doesn't matter.
Hold it. You cannot, he's got the floor.
Yeah, I didn't say anything. What's your side? Yeah.
Steve, I'm not.
Right.
Okay.
But there's just a moment. There's anybody who's speaking is only addressing the board.
So you face this way.
Right.
And Mr. Goodall shouldn't be addressing the audience, and the audience shouldn't be addressing him. So
Right.
let's try to keep order here.
I apologize.
You know, when I give speeches, I address the audience, so it's a little hard to.
Your
Oh, okay, okay, fair enough. Okay, so on the statute, PennDOT was at fault, right? In our opinion. Now, the board at the last minute, right? Again, they're basically making decision. They had a 2-0 voted because the PennDOT guy had to recuse himself. So they say on Monday night, after the thing came out on April 24th, a Monday, that, no, we misheard each other and it was really 0-2 the other way. Instead of two of us saying yes, we really meant to say two of us said no, right? That on its face is ridiculous, okay? And also PennDOT, I keep hearing murmuring over here. And then PennDOT was going on for 3 months, basically saying, I mean, the Board of Properties basically went on for 3 months, basically filing an opinion on our ruling, which was well reasoned. Then all of a sudden, the next day they come out with a different reason in 100% different direction. Meaning what? For 3 months they're writing two opinions. Who does that? No one writes two opinions. It was, we happen to have this one on the shelf and that one's not on the shelf. It's ridiculous. It's absurd. Okay. The most interesting point is that in the condemnation, and again, this does not inure well to PennDOT, is that they condemn my property, which of course they had already said in one court that they own it. They condemn my property in the easement case, which I had to spend a lot of money on to fight, the Board of Property case. They say they owned it. In the condemnation case, which I also had to spend a lot of money on, they say they don't own it, right? So all you lawyers in here basically can say, like, is it legal to say in one court you don't own it and in another court you do own it? I think that's fraud, right? I think that's actually illegal. And I think some lawyers on that side are going to have to pay heavily for that. Okay. So don't be jumping on the bandwagon that we're unethical and they're so ethical, because they're not ethical. Okay. And the last point is, and this is a new one, that when they condemn the property, okay, and Eleanor, I'm actually going to address you correctly because you're directly, and Steve Harris knows this too, both attorneys, so it's easy to address the attorneys. When you condemn, you have a grantor situation and a grantee situation, right? So PennDOT, when they condemn my land, again on false premises, but whatever, we have the right to appeal it like everybody else in the room, right? The grantor was PennDOT the day of the condemnation. Then the grantee rather, the person they're giving the condemned land to, should itself be PennDOT, right? PennDOT condemns the land that's one arm of their department, and then they give it to themselves so they can do the repair work or whatever they want to do on that. But they didn't do that. The grantee of PennDOT's condemnation was Vertus Capital Advisors. They condemned the land and then gave it right back to me. And so within 1 hour, the land that they've been condemning, they gave it right back to us, right? So they have no land right now. So everybody who thinks you got on top of it on the lawyer side, all your lawyers, you can just start asking them, who owns the land as of this moment right now? Every road leads to me and my corporation. They don't. PennDOT has never owned this land. They may down the road own it, but every permit they filed right now, and everybody needs to absorb this, is invalid, absolutely invalid. You're all going back to square one. Now, here's the good news. Someone has contacted me, a group, because Rich and others had said, hey, if you can find money, do it. We found money. If somebody's contacted me, we found money to rehabilitate the bridge and to put a 1-lane bridge in there. Now, I see people shaking heads. You guys want your 2-lane superhighway. You guys are tucked in your little Quail and McCann roads. You guys are insulated from all that, right? Of the superhighway that's coming down. But when these trucks starts rattling right through the middle of Tinicum, this town's going to be destroyed. And you don't need really me. You shouldn't be relying on me to save this town.
All right. Thank you, Steve.
All right.
How do you know that? I'm sorry, I couldn't stop myself.
Does anyone else have a comment on the bridge?
Back for the insults next meeting.
Again, I guess a question I would have for Steve, Steve, based on the first request that we got, if the township were to address the legitimacy of the lawsuits and or the lawyer's actions for any of the current situations, would that impact any of the current litigation in any way, shape, or form if a decision was made one way or the other?
Well, first of all, I don't think that the township has standing to file a complaint. Because it's not a party, to any of the litigation. So I don't think we've got the standing to do it. And number two, I would assume that if lawyer A was found to be unethical, with whichever side it was on, it would be replaced by lawyer B. So I don't think it would make much of a difference.
Well, something you could look into maybe a little
I
bit
don't
more for the
understand.
next
What
meeting.
did you, I don't understand what you just said. Can you
Well,
repeat that?
okay, what I'm saying is assume that that the Attorney Conduct Board actually said a lawyer had acted improperly in filing a paper. And I don't think that as long as there are appeals going on, the board would ever entertain that. But assuming that they did, I assume that the party, whether it's Mr. Gittimal or whether it's PennDOT or the Riverkeeper, simply hire another lawyer to replace that person. But I'll look into it.
Mr. Chair, could I ask a
Also-
question, Steve?
Yeah.
Steve,
Yeah.
remember we talked about, I think the last meeting, you said that there are some people that have financing in place for a rehabilitated bridge?
Yeah.
Are they willing to come forward and
Yeah.
address the board?
I was speaking to them, actually almost an hour before here, this meeting. Yes, they're doing some, development work on it. They want to come to you guys with a fully packaged, thing with the budget in place and,
Do you know when roughly the timing?
Yeah,
on
I
that
think
is?
they're about less than a month away from it.
Okay, thank you.
So just as everyone online, Steve just said, about a month away, Mr. Gittimal talking to Rich, about a potential package. I know with the mic and everything. Just want to make sure everyone's aware. Let's listen. That's all. Any other comments on the bridge?
Tim Cashman, resident. So when you start looking at another bridge, is it gonna be able to handle school bus, fire truck? Is that still what we're looking for as a supervisor board? for the
Yeah,
township?
currently, the report that we got, if I remember correctly, what was the weight limit that they came up with the structure as is, was it?
Well, what it could support right now with the study that has been done,
Correct.
but there is another study that we're still waiting for, right? We talked about that at the last meeting, that the Riverkeeper still needs to provide an additional study that they did to see if it can support more weight on that bridge. Because I think currently, don't hold me to this, but I thought it was around 10 tons, something like that. It's unacceptable in my view.
18 last time.
I'm sorry, what is
You
it?
said last 18. right?
18, that's the one, 18?
Thought it was
Still,
around 30,000.
still unacceptable because there are heavier vehicles that use that bridge.
Yeah,
So that's where another investigation was undertaken that we're still waiting for that report. So
did you not speak to PennDOT about that? I thought that report came in the same as,
no, PennDOT's position has been from the beginning, whether it was a one-lane bridge.
no, I'm saying the report was the same. I thought you didn't receive that report yet from the private
No, there was-
organization,
There
the
was
Wood Tiger
additional
Fund?
work that's being done on that, on the subsurface. That is gonna either confirm that it can only be 18 tons, or it could be greater than that.
Rich, I think it's okay to just point out.
Yeah, Steve. Yeah.
Yeah.
You have to wait your turn. Sorry. We have too many people.
Well,
Sorry.
So in that sense, if it doesn't reach the point of a fire truck or a school bus, the township doesn't support that.
It becomes it's not viable structure. I mean, basically what we're trying to accommodate is those vehicles, but also local contractors, because we know there are stone trucks and dump trucks and those types of things that would end up going over it. And we want to make sure that whatever we put there wouldn't get damaged by an overweight vehicle ending up over it. Not necessarily worried about long wheelbase like tractor trailers, as they probably couldn't make the turns, but there are smaller trucks that are heavyweight, dump trucks, dualies, triaxles, things like that are in the township that we wouldn't want to potentially have a bridge that they could go over, but then damage by going. So
The last thing I want to ask about was the testing that was done on the bridge that was supported by who?
that was supported by the Wood Tiger Fund, funds to us.
And was that also supported by the River Keepers?
Yes. Well, I mean, it's through the Wood Tiger Fund. So
Okay.
not any relation to
So
anything else.
that being said, we don't have any results on that yet?
We have an initial report based on, but because the report came in at 18 ton, around 30,000 pounds, somewhere around that range. We wanted to have a conversation and ask to see if there's additional studies, because again, this was a cursory study based on digging next to it, seeing what the footings were made of, without doing drilling, and seeing what they think that the structure as is, without doing any improvements to it, what it could support.
Okay,
Uh,
this study was already done by the state of Pennsylvania.
It might have been, but this was one that the engineer, Doug Bond had done independently based on the information that we gathered from, stuff that PennDOT had done in the past.
Mhm.
They provided us with the reports and studies that they had done, plus the additional investigation that we did this summer.
Okay. Okay,
Jim, I want to do-
thank you.
Steve, if you could, if,
And
I gotta
get up and get up. He moved to the other meeting.
No, he's gotta get up.
that's a he didn't make a comment. If you want something to be recorded, Steve, you gotta come up.
Okay, I'm sorry, no, I just want you to know.
Okay. Yes, Kathy.
Catherine Auerbach Center Road. And I've been studying this bridge for 20 some years. And the reason being, it's on the National Register. It's one of only 2 of its type recorded. And when we started studying it, it was in very good condition, basically. Several holes in the deck. And PennDOT, it's an inspector, holes in the deck. Substructure was good. They closed the bridge ultimately. First they downposted it, then they closed it because of the holes in the deck. And then left it be. Did not do any repairs to a bridge that's on the National Register. The federal law states that if a resource can be repaired or rehabilitated, that's what you do. They were using federal funds and they were manipulating all the studies to change that so that they wouldn't have to repair and restore the bridge. We did measured drawings and found that it was very stable. So I just want to clarify that the substructure surprisingly was good. Your consultant and your studies more recently have confirmed that it is sound. And I appreciate that you're clarifying the tonnage. As I understand, many times when they do those studies, they post at a certain weight, but yes, it can carry heavier. It's just a matter of certainly not encouraging that on a regular basis, but yes, it can. So thank you for asking for those clarifications. And the point about the creek and the stream, that there are documented maps before the bridge was built, 1790s, that show the path of the stream. And it is exactly where it is today. The bridge was built and that has held the stream in its original path. So drawings that were done for land surveys for the 1830s and 1850s all show the creek following its path. What PennDOT is proposing by moving the abutments will throw the creek entirely into the meadows and change its path. So it's a very dangerous scenario that they're proposing by moving those both abutments east and west over, and also building basically a dam in the middle of the meadows to obstruct any floodwaters or excess water. And we saw what happened because they had raised the roadbed a little bit, that dug out 8 feet on Mr. Goodemall's property because of that slight elevation. And then now they're proposing concrete and basically a dam across a floodway. So that's also illegal. Federal law states what they should be doing, and they have tried to go around it. So that is certainly a concern and something that many of us in Tinicum who appreciate the historic ambiance, who appreciate the natural resources, that bridge is historic, the creek is in its original path, and the bridge has been holding that way. And a former resident for a long time, James Mitchner, on another issue about the creek, wrote in one of his publications, what was I doing that was more important than saving the creek and saving the quality of water and saving these things, when he found out that there was some jeopardy with the Tinicum Creek. And that was a national publication that he wrote. It was like, he realized this is important. Our state constitution states, Article 1, Section 27, that the citizens have a right to clean air, clean water, and to the protection and preservation of our natural, historic, and aesthetic environments. And that's something that you would take the oath of office to uphold. So I appreciate that you're following through on these studies. I think it's fantastic that the reports came through to affirm what we saw, that the bridge can be rehabilitated and that there's potential funding to have that done, and that can be the fastest track. And so I thank you for following through on these studies and considering that possibility of rehabilitation of the bridge. We have something very precious, and we can get it done quickly. Thank you.
Anybody else have a comment on the bridge?
Gary Wertz, I'm on Quail Lane. Wasn't I at a meeting about 8 or 10 years ago where they had some hydrologists come in that was in favor of actually diverting the bridge or the water away from the pilings of the bridge to try to salvage what was there. So at one point I remember rechanneling that the actual stream was what was being pushed as the way of solving our bridge problem. Anybody, I remember that distinctly. There was a hydrologist that came in and he was in favor of doing that. And at the time I heard no one saying, oh, you don't want to do that.
I recall, I don't know about the hydrologist, but I do recall there was some drawing or something that was done, whether it was through PennDOT or some third party, that they had some sort of baffle around the piers to divert the water away from the piers so it wouldn't undermine the piers. I recall that, but I don't know who presented it, to be honest.
It was so long ago.
10 years.
That's, you know.
It's like a lifetime.
I ran the numbers on the cost of extra gasoline for people in our that live where we live for the 12 years. 6,300 and change over 12 years. It's not 12, it's 11 3/4, right? The number of days, extra time that we spend out on the road, 600 some days of extra time. And in terms of our environmental impact, I don't have the numbers here. I sent them to some friends. The amount of carbon dioxide that gets thrown into our air because of all those extra hours on the road is certainly not environmentally friendly.
Could I ask a question? Because I know you live up on Quail Lane, so probably a lot of residents that live there. Would there be an objection if the studies show that a rehabilitated bridge can support the traffic that we want on the bridge, that we know is going to use that bridge, number one? Number two, it'd be totally funded by some outside source, so that there would be no cost to the residents of Tinicum. And it would be a one-lane bridge, but it would be a rehabilitated bridge. Would you and any of the other folks up there, would you have an objection to that?
I can speak for me.
Sure.
And I bet I'm speaking for most of the people in here. We just want a bridge.
Okay, so that's my point.
And you know, what I don't like is being categorized as the non-environmental people here. I moved here because I like the environment around here too. So that's not something that the other side has a monopoly on.
So what I'm asking is,
But the answer is, for me, absolutely. Let's get the bridge.
but by virtue of the hand clapping, I suspect that a lot of people feel that way. So I ask that give us that opportunity to get the additional information that we've requested, that they're funding. It's not coming out of taxpayers' money here. They're funding, and that we may be able to come in the next, now maybe not the next meeting, but the meeting after that, but very soon, and say, hey, we think we've come up with a solution. And there is, according to Mr. Gittleman, there is going to be funding in place that we can present to the public, and then we'll know where we go with that. Just give us that opportunity to get
I think
that
that's
funding.
reasonable,
Okay.
but I think we've been more than reasonable.
I know you have. I
11
think most
3/4
people-
years,
yeah,
folks.
yeah.
And there's one other concern I've got, and that's for my neighbor and threats. What is that? Aren't we all Tinicum Township people here?
Yeah.
We may be on opposite side of the political aisle, but I think we're all here because we like living here. We like the environment around here, and we need a bridge. And we don't begrudge Mr. Godemol to have things the way he wants, as long as it works with, kumbaya, right? I'm sorry?
You suggesting.
I never said I didn't say you.
All right, stop, come on.
No, I'm talking in general. I mean, I don't think that should happen, and I don't know what's protecting that. but I think in a public forum here, I think that needs to be raised. So anyway,
Okay,
thank you.
so,
Thank you.
thank you.
Anybody else have a comment? No? I guess being that everyone's here for the bridge and if I have one more meeting after this to go, I've just, I'll make a comment on, all this and the 6 years that I've spent dealing with this. I feel I think that some of the arguments have been being raised for the bridge to not be built by PennDOT and this and that have been a little bit disingenuous and sort of nonsensical. I also think on the other side that, rehabilitation and not going down that route from PennDOT is also sort of nonsensical. And so we've been put in this middle of this nonsensical argument from both sides. At this point in time, Steve had mentioned that there is a group of people and I would challenge them to actually come forward after talking about this for 2 years, Steve, since you've been here and promising and saying that there's, that there's money somewhere available. And, I would challenge them to come forward and please do that. And we do have some information. Again, the bridge is, as is, the structure would be okay for around 30-some thousand pounds. There's some improvements that could be done that we are waiting to have a conversation with the funding people who are doing the studies, that if there were some micro piles that were put and drilled into those, that we could substantially raise the existing structures to a higher load rating that would give basically the township what they would be looking for and would give, the other side what they're looking for is keeping something that looks and is mainly historical, but with new concrete inside of it that keeps it supported. That seems like a reasonable thing. There's been a lot of money in the past 12 years that have been spent towards both sides, one side by the state, one side by a private entity. I would challenge that private entity to put some money towards, coming up to a resolution and meeting somewhere in the middle. And hopefully this would get, on a short path to getting something across that bridge, that creek. Yes, Anita.
Anita Nolan, resident. I just want to say we aren't the other side. We are the residents, and I don't appreciate being termed as such. Thank you.
I wasn't really making mention of you as the other side. We are the other side, Tinicum. Tinicum it's been Tinicum on the sidelines, Anita. We have not been party to all this. We are in the middle of this. We are between a private group arguing over some nonsensical environmental discussions and the state also arguing over some nonsensical funding requirements and not wanting to give a community what they actually want.
I'll be real quick.
Just, Rich, to your comment about, I suggested to the board a couple months ago, that I could probably, or you challenged me. You said, if you think you can come up with money, come up with money. I had a structure at the time, that's since evolving that structure. I did make some inquiries and now we have, I would say a very active and committed third party that would like to do the bridge as a rehabilitated bridge. That money, we've checked into the money, it's there, and they're motivated. Okay, so I didn't hear any cheering when I mentioned that earlier, but now, I mean, maybe there will be some clapping since everybody, of course, just wants a bridge, right? Then we could, that could solve the problem. The other thing, and I think really everyone that's on the 2-lane bridge side needs to absorb this fact, right? The reason this has taken so long is that there've been, and again, I've only been involved for 2 years, right? So I have nothing to do with the 10 years. And frankly, if they had disclosed that they were going to build a super highway through my property, I wouldn't have bought the damn thing. Okay. So, but for the last 10 years, the reason it's been so long is on the one side, you got some legitimate arguments from the environmentalists and from the historians. And on the other side, you got PennDOT pushing hard. And yes, maybe the people on the other side, particularly in your area, which I think is a real, I don't know why you guys are so angry about. So it's such a beautiful enclave up there, that McCann and Quail, it's beautiful up there. I mean, you guys, that's so beautiful, but you will be insulated from the truck traffic. You won't hear it. Some of you guys in the back that I think there's a few houses even look over my property and it's beautiful up there. You won't hear those trucks, right? Other people will. I mean, the trucks that will come are going to destroy my quality of life, but I'm not against that. I'm up for a single lane road going through it. I'm willing to do it. So I bought this thing not knowing about it. The other thing I would say is that when you guys, if you really want a bridge, you got to get the next the supervisor group to say, we want a bridge, not a 2-lane. Everybody on your side has been saying 2-lane, 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 because that's, look, I'm just telling you what PennDOT's been telling me, right? PennDOT has been saying,
Steve.
oh, it's okay.
Yeah.
PennDOT has been saying that the only way we can do a bridge, and the only way is if it's a 2-lane superhighway bridge, okay, with a dam that Kathy pointed out is probably illegal, right? But PennDOT has bullied this township for 10 years, and guess what? Some people push back. The environmentalists and the historians, well before I was involved, have pushed back. My only issue is that they have illegally seized some land in my property. If they had disclosed it, I wouldn't have bought it. I wouldn't be here. Everybody'd be much happier, right? So, but they didn't, right? So I think at some point people have got to rally around a bridge, and if it's a single lane, people should be happy about it. And if you're not happy about it, then you're really showing your hand. You really want a super highway, and you should come out and say that, because I don't think anybody, I have not spoken to anybody that's crossed my property that wants a 2-lane bridge there, not one. And all my neighbors, even though they don't show up here, and I'm a little pissed about that, they all say, Steve, keep fighting, because it's crazy what PennDOT is going to bully us through. So I'm telling you, I'm feeling the pressure from 10 direct neighbors that do not want me to give up, right? And I wish, I don't know, maybe they're under there. Maybe some of them are under there. They're not there. They didn't come out in force like you guys did. But I'm telling you, I get it every day.
I guess I'd just like to make a statement. I'm pretty sure that I probably speak for the majority of the township saying that no one actually is actively asking for a 2-lane bridge. I think people are just looking for whatever structure we had available that the township did not have to take over and then pay for and maintain. And that happened to be based on the discussion, is PennDOT offering federal funds. It was a 2-lane bridge, and there was no funds to do elsewhere. And they said specifically that no one wanted to do a rehab. And we've said since I've been on this board for 6 years, we've been sitting here saying we will do a rehab if someone would be able to fund it and the township doesn't have to pay for it out of pocket. Because the town, we're a small township. We operate on a $2 million budget. We can't build a $2 million bridge by ourselves. Or by the time we're done with engineering, $4 million. So,
Last comment, I did speak to the president of the Wood Tiger Fund about that, and asked him to do that. I said, there's been enough money given, over $8 million to the river keepers. When you check the 990 form, you can look that up on ProPublica, and you can see all the money that was spent to them over the years. It ends up being about $9 million. There's other areas in the community that receive money that speak in favor of them. You can see their names on those filings also. So there's a lot of money that was already spent, and I've asked Bruce directly about that. And I'm not going to repeat what he said because he's not here to defend himself. But I wish they would come up with money to pay for that. If someone wants a 1-lane bridge, I was always in favor of that. The neighbors I spoke to, I can speak for them. We just want a bridge. It had nothing to do with the 2-lane. It's never said it was a super highway. If they do 2-lane, they own the bridge. Why should Tinicum pay for a bridge? That was always my question. So thank you.
thanks.
Sorry, very quick. Amy Glascott, Tinicum Township. And I guess if we're looking at a private funding source, I mean, again, I just want a bridge. I don't care how many lanes. Can there be some sort of timeline put on it? Because again, it's been almost 13 years, and we would just we don't want this amorphous, oh, they might pay for it someday. That's all. Okay.
So just as a note on that, just so everyone's on the same page, if we were to get funding for something of that nature tomorrow, there's still a time frame related to design, permit, and build. So just understand that. Yeah. But just understand that it is not an instant. There is still permitting, there is still design and all that has to go through that. Temporary bridge is not a viable solution without doing the majority of the work that requires it to be rehabbed because of the deck thickness that you'd have to do for a temporary bridge. It sits too high, and the road would have to be too high, and the approach angle would be too much. So to do anything, you'd have to take off the deck and basically build a new deck and take down part. You have to do 60% of a rehab to put on a temporary bridge. So it has been investigated. We have found structures and companies that do those, but it's just not a realistic solution. A more realistic solution based on the dollars to be spent would be to just rehab it. Yeah. So again, we've been going down that path this year. I hope it continues after I'm gone, and I hope that we get some resolution and some funding and could be done with this discussion in this township. anyone has no more comments, gonna move on to the next topic. And like I had said, we're gonna bounce around a little bit. And we're gonna move on to conditional use and zoning, item 3, which is the Andreessen zoning hearing board application, as I see that we have some folks in the back with a bunch of billboards and maps and whatnot. Yeah, I'm gonna go through because I know you guys are prior to that, but we'll be quick. Fascinating. All right, well, everyone's shuffling around here, getting ready. This is for a zoning hearing board application ZHB 2023-11, Jamie Reedy and Stephen Andreessen. This is at 21 Tedderman Road, and this is a 88.85 acre property. The applicant requests relief to construct a new single-family dwelling and a 3-car garage with an in-law suite on the property, which already has an existing dwelling, without land development, pervious surface of 9.2%, allowed disturbance of steep slopes, steep slope buffer, and riparian buffer zone. The planning commission has reviewed this on 11/28 meeting. At this meeting, we are deciding whether to oppose, not oppose, or be neutral on the zoning hearing board, which is scheduled for 12/14. So I see that we have a lot of stuff here. I understand you guys spent a decent amount of time at the PC. And before we go into a big presentation, I guess I would like to make a motion based on my reading of what the PC minutes were. It seems like they were asking us to oppose, but had some interesting language in there about also agreeing with your approach in some way, shape, or form. So it seems a little bit of a conflicting statement based on prior zoning hearing board applications, unless someone is actually coming in and actively going against something that our zoning officer has said, or it's something that we found someone to be doing legally, and then they have to go to zoning hearing board. We've typically let these things go through the zoning hearing board on their own and let that board make their decisions. I would make the motion to have that happen, but with having our zoning officer there just to clarify any questions that any side, either the applicant and or the zoning hearing board would have, being that this seems like it's a pretty technical and there's a lot of items back and forth. Which you guys said we do not oppose, but we send the zoning hearing board or the zoning officer for questions and clarifications.
Second.
I assume that since one of the things that you guys do, I assume that that would include not sending the solicitor.
Not sending these, just because this is there's a lot of items related to your request on the zoning variances, to make sure that the zoning hearing board and yourselves all have the correct information, or at least have someone to reference for back and forth. I would request them to go for that purpose, but not send Steve, and the township would have a neutral position in this decision, as
Yeah.
we typically have done in the past.
Excuse me, board. As there was a long review done by Wynn Associates, did you want zoning officer and engineer he wrote something based on land development, which wouldn't be the zoning, or do you just want the zoning officer? Just for clarification.
I mean, we do have the letter. Typically we would just send the letter from the engineer.
I think I'd be fine with just a letter, as long as the zoning officer is there, because he initially had some questions about it, so he can answer questions that either side may have. So,
yep,
that's why I think that might be.
Yeah, I guess before we would take a vote, we give you guys the opportunity to give us a shorter presentation, as we've been pretty inundated, and we still have a couple.
Give you an executive summary if you're willing, like
That-
your schedule, is that
That
5-minute run, is that okay?
that would be fine. Thank
Great.
you.
thanks for putting us in tonight. I appreciate how busy you are in getting us in. This is a time-sensitive issue. I'm with our client, Steve, Jamie, the owners of this property. Their concept is they wish to put a conservation easement across the 87 acres. They wish to do it as a donative easement. They have time constraints. They have a one-time opportunity this calendar year to be able to make that offer to the township. We're all excited about it because that will leave township funds that are for open space that perhaps are very much needed for people in farmers, et cetera, people that really are in need of cash now. So that making this easement take place, this is the fourth largest unconserved property in the township. So we're excited to be part of doing that. The general concept of the planning commission, I could feel they liked the idea, wanted to make it work, but we came back to subdivision. The subdivision was not for a purpose of future monetary gain. The subdivision was exclusively as to allow family succession to continue to reside there with bearing different financial responsibilities. Steve and Jamie are passionate enough about the property, want to make the donative easement, love it, want to live there, want us to restore historic barns, want us to continue to do improvements to the historic structures. And as such, we'll work out the family-related finance problems for future holdings without the need of subdivision. When one takes the subdivision away, the list dramatically lessens of what we're planning to do. In summary, there's an existing barn that's, Jeff Marshall is here tonight, but I won't ask him to comment based on time unless you request at the end. Anybody I mentioned, if you want to hear from at the end, please just prod me. I just want to respect the time you've given us. So Jeff is here tonight to talk about the very significant attributes of both the barn and the house. Jim Engel is here tonight, who has spent a tremendous amount of time. I've spent way too much time because I'm passionate about trying to make this work. This just makes so much sense. And as I tried to explain to the planning commission, I realize that we're looking for some exception, but it is all in the good of this preservation. Jim can equally speak to the many hours. We have a closing scheduled in conservation easement by the end of the year. And to make that happen, Steve and Jamie need some assurance that they can do the following. Number one, we're going to do repairs and work on the barn. They've agreed to not use it as a guest house out of fears of the township possible suggesting problems with Airbnb and so forth. So the barn will be restored, taken back to its historic correctness. I'd asked Mrs. Arabak, who's a scholar of historic correctness in Tinicum, to visit the barn, spent some time with her, was drawing on her thoughts and opinions. How do we restore the barn? Of course, Jeff Marshall's on relentless knowledge of architectural purpose in barns equally will be participating in that. The bottom line is the barn will be brought back to historic correctness with its use being a exercise area, craft area, enjoyment for the family, home office work. That's it. So that leaves the existing farmhouse. We've done a tremendous amount of restoration to cure some major environmental problems from wetness in the basement and done repairs of cornice work and things that have been historically correct, brought them back into good, correct wearing order. So the house will be now going as that guest house for kids, guests, so forth to reside at the existing home. Steve and Jamie wish to build one house up on the top in a meadow. We've agonized to keep the driveway is already there by virtue of farm roads. We are virtually the minimus of any cutting of trees or modification to get that road across the steep slopes that exist. You could drive a high-end sports car up it as we speak today, or a dump truck. It's there and in good working shape. The other building that resides there is this building affectionately known as a sugar shack. The previous owner did maple syrup processing. That stays and will remain. So in essence, what we're seeking relief on, Jamie's mom, who's in her mid-80s, is now facing some mobility issues. Out of this 85 acres, there is not a garage on the property. The barn in the lower section is all set up for animals and from 100, 200 years back. It's a shame to defile it, cut it, ruin it, chop it. Jeff and Mrs. Arback can speak to that. So we're looking to do one garage that will be adjacent to the house. It will be tucked into the hillside. It will act as a bank barn where the walls of the garage actually are the retaining walls to the hill. Consequently, we have a 49 by 28 poke into the hillside, which will require steep slope relief. Equally, that is in a that is also in a relief area in the bottom for riparian corridor. So it's this 49 by 28 poke into the hill. It fronts right on the existing driveway. So 3-car garage, apartment for a mom, and on the top building there, retirement home, 4,000 feet, in scale, in scope, in vernacular that's befitting. In an open meadow, that's the scope. No agenda. Wants to do preservation, everything is aligned in their lives to be able to do it this year. After this year, the financial opportunity goes away, hence the big race to the finish line. And restoration, preservation, and again, as Jeff would testify to, it's not just preservation of history. This is a resource laden property with amazing features, and by preserving it, equally will stop an occupant there from possibly defiling and causing problems, whether it's within zoning or not in zoning. It's a area that just goes away in perpetuity. That is the long and the short of it. There's a lot of really great reasons, and the clients are passionate about making this happen. Hence, that is why we are here this evening. That's the quick summary.
It was an excellent executive summary, I'll tell you that.
And so the experts are here that can answer any questions.
Yep. And I guess, from my point of view, I appreciate everything and the idea behind it. And it's just that I hope you appreciate that we do have to follow regardless of the presentation. That's why we have to push this to the zoning hearing board. It is their choice, is their decision to make, because there is zoning variances that are needed for what you're asking for. And it is that board's position in the township to make those variances if they so choose to.
Understood. With the catalyst being out of the almost 88 acres, arguably one cannot even have 3/4 of 1 acre of zoning, which would have made it in violation 200 years ago when it was built. So
Yeah,
it's
we have a lot. Yeah, we have a lot of historical properties that really don't fit with today's thing. But today's zoning is for a purpose, and
and I understand the difficult level that the board has to navigate, so that this is not used as a weaponized product somewhere else. I understand.
Yeah. So again, back to my motion, I guess I'll just reiterate it, is that I would request us to take, not Steve, take a neutral position, but do send the zoning officer to make sure that the fine details of everything that they're looking for in variances, there's a reference for questions and answers to come back.
Yeah, for both sides.
Yeah.
Finally, I just want to thank both staff and you for allowing us audience under such a short time constraint. It's very much appreciated by both myself and the residents. Thank you.
Thank you.
All right.
You have
Any other questions, comments? You have anything?
I don't have any comment.
All right. All in favor?
Aye.
Aye.
Thank you.
Thank you again.
Good luck at the zoning hearing.
Thank you.
Oh, you have to, all right, while everyone's shuffling around and moving out of here, we'll continue on with old business. We have a cryptocurrency and an intensive digital computer operation ordinance that is advertised for adoption on December 19th. That'll be coming up in the next meeting. We also have the subdivision ordinance amendment, which has been advertised also for the December 19th meeting.
Excuse me, Steve, have we gotten any comment back from the Bucks County?
No.
Okay.
No, as soon as, assuming that they do comment. Assuming that they do comment, I'll get it sent to the board
Okay,
immediately.
thank you.
So I just have a question on the ordinances that we have in our packet. There are no numbers. The numbers come when we ultimately decide on it. Okay.
Yep. I guess we'll jump over Hank and Ben.
Well, I don't think you mentioned the speed limit ordinance as well. There are 3 of them.
Well, he's jumping over.
Oh,
No, that's actually not on.
You're not? Okay. It's on there.
Oh. Maybe I'm looking, okay, I'm using it. All right, so we also have a speed limit ordinance advertised for December 19th. I believe that one's the one for Hollowhorn Road and Stagecoach. Stagecoach originally.
And original.
Yeah.
We're gonna skip over Hankin and Van Louvenet, presentation just to get through the rest of old business, then we'll come back to it. For the 2022 tax collection cleanup, we have to open an account, to rectify our 2022 tax issues.
Yes, it is. In order to straighten out some of the issues that we had from 2022, the county has asked Deborah Yerger, our current tax collector, to sign on as deputy tax collector for 2022 so that they can get through, as much as possible, the cleanup of the problems that we had due to the tax collector in 2022.
So Steve, do we have to make a motion to have that account opened?
Yes.
Okay.
Before we do that, Terry, can you speak to Deborah Yerger being appointed deputy tax collector?
Yes, so
How did that come about?
That came about through the county tax offices. They desperately needed help with, and you'll see in the disbursements, the money that had to be returned to them. However, there's no problem with the budget. I knew that money was going to have to be returned to them and it was put in a liability account. So we are fine with what we expected last year and what we received. But in order for the county to properly disperse the money, we would have had to, without a deputy tax collector, the county would have had to have the check made out to the previous tax collector. And so this was the legal way that the county tax office and the county attorneys decided for it to be handled, is to make Deborah the deputy tax collector for 2022, even though she is tax collector for 2023.
Okay,
By whom is she employed? The township or the county?
I believe it's the county because the direction came from the county. So the township has never specifically employed a deputy tax collector.
Is that?
It's up to the tax collector
Well,
to handle that from their office.
well, I assume somebody's gonna pay her.
That,
I would assume it would be
that
us.
was not discussed with me.
But I'm only I mean, it seems to me that she is the township's deputy tax collector, and the issue of whether the township is going to hire her as the deputy and pay her ought to be resolved, and maybe that ought to be, this ought to be tabled until the 19th and get an answer to that question.
Yeah.
Because I understand what you're saying. I mean, you know, you're saying, well, the county has said this. Well, that's very nice that the county's saying it, and I understand why the county's saying it, and I understand the reason to appoint one, but it seems to me that it's the township that's appointing this person, so we need a motion to do that. And it would seem to me that she's liable to be saying, I ought to get paid. And that ought to be worked out, whether it's the county or the township that's doing that.
I'm gonna sound. The check that the county asked for, the money is owed to the county, right? So if the county is asking for the money to be dispersed and the check was asked to be written to the County of Bucks tax offices in care of Deborah Yerger, my assumption is that she will be refunding money and acting as deputy to the county, and therefore it would be the county. So when they didn't discuss payment with me, I assume that's because she is dispersing the $60,000 that is the county money. Did you follow my?
I understand that, but
Sounds like
it's
Steve,
the
what's your
township,
suggestion?
it's the township that's refund. If the tax collector was still around, he'd be doing it.
That's correct.
So while the money is going to the Bucks County Tax Office, it's going there because it's due them as a refund, but it seems to me she's handling that as a pass-through as the township's deputy. Now, it may be that if all that's happening here is opening a bank account, putting the money in the account, and then transferring it to the county, and that's all that she's doing. This is, an exercise in how many, lawyers can figure out how to complicate things. But seriously, if that's all that's involved, I still think that it's the township deputy tax collector that's opening the account and paying the money over to the county.
I understand what you're saying. However, all of the Tinicum tax collectors don't simply get paid only by the township. They get paid by the county and they get paid by the school district as well.
Okay.
So perhaps I'm mistaken, but I assumed this was for the county portion.
I don't.
Do you understand?
Well, it's
so-
your next to the last meeting, so I wanted to make sure
Yeah,
that I
that's
be on
fine.
the bus at least once. So, but seriously, it does strike me that this
Right.
woman really is, she's paying money that the township improperly collected and refunding it to the county. It just appears to me.
Mhm.
she's-
So is it a
Wait a minute.
one-time fee you're thinking?
No, I refunded the money to the county.
This is to distribute
To
those funds
distribute
to individuals.
For the county to
For the county.
individuals to
Okay.
straighten out the mess. So I'm the one that is giving the money as per all the auditors on the county level and the township level.
And you're
I-
giving it to Deborah Yeager, who's then going to be distributing the money to
I'm-
various
The
persons.
check is made out to Bucks County tax offices in care of Deborah Yerger, deputy tax collector.
I think it's worthwhile to to confirm. To confirm.
I
It's
also-
fine, that's fine with me if you want to
Mhm. I
think
confirm
that-
it. The only thing is I was trying to get everything done for you for end of year, but it is fine. I can send it all to you, Steve.
Oh, thanks.
I also think that it's important. My recollection is that the tax collector is the one who typically selects a deputy tax collector, and that in this instance, the individual did not do that. So I would also want some reassurance that we can do that ourselves. If the tax collector doesn't do that, can we deputize another tax collector?
The way this came up, yes,
Okay.
because you recall that that's how Deborah was appointed 2023.
For the current year, but this is kind of retroactive
Yeah.
to the 2022 year.
I don't have so much of an issue with that.
Okay.
I do have an issue with trying to figure out who's really appointing her and who's gonna wind up paying her if she's looking to get paid, which I would think she is.
Okay.
Now, and you may be right. It may be that the county's gonna be paying her because she's distributing money on behalf of the county.
So you're gonna look into it for us?
But you may be right, and maybe she will end up distributing money for both.
I think that
That's-
Harry and I ought to try to get on the phone tomorrow with the person at the county tax office. And maybe, I forget the attorney that we've been dealing with on this thing, the assistant county solicitor, but just get an answer. And then, yes, it means that it's gonna happen 2 weeks from now after Terry's not here, but I just think that there's a potential for misunderstanding.
Thank you.
All right, so we'll table it.
May I ask one more question about this? Should the check be signed and given to the bank and finished, or should that check be held from disbursements? this
Well,
point? I mean, it can hold till the 19th if you think that's better.
She has to open an account to put
That's
that money
correct.
into it.
That's correct.
I'd wait until the 19th.
That's fine. So all, when we do disbursements, we'll say with the exception of.
Right. Well, the board could authorize, well, no, it's 2 weeks. Let's get the right answer and do it.
So we'll table that to the night. Moving on, resolution accepting the lands of Callie Iden Agricultural Security.
Yeah, now with regard to that, let me get these things in order, because I got a bunch of stuff to sign. There, the board needs to adopt a resolution accepting the application of Callie A. Iden to join the Tinicum Township agricultural security area and provide Ms. Iden with an acknowledgement of the addition of land to the agricultural security area to record with the recorder of deeds. So I would ask for a motion to approve a resolution accepting the application of Ms. Iden to join the Tinicum agricultural security area.
I'll make that motion.
I'll second.
All in favor?
Aye.
Aye. We also need a resolution for Rich and Kim Rosamilia's authorization submission for advertisement and posting for their ag security.
Now, this resolution authorizes the submission of an application to join the Tinicum Township agricultural security area to the Township and Bucks County Planning Commissions, and to authorize advertising and posting. The application is required by the agricultural security area. We'll request the motion for that to adopt that resolution. Excuse me?
I'll make that motion.
I can't second.
Oh, I'll second.
Comment? Yep.
Can you guys tie your approval to his approval of a one-lane bridge?
Good try. Good try, Steve.
All right, all in favor?
The other guys have left. It's unanimous.
All in favor? Aye.
Aye.
And then lastly, Jim and Christina Helms, my ag security finalization and recording, and I won't tell my wife that you spelled the name.
I'll make the motion for that.
Well, actually, we don't, you
We already
adopted
did it. We just gotta
the
sign it.
Okay.
resolution.
All right, so
I finally brought it in.
I now have the acknowledgement I'll take that back. No, you've got to sign, so it would be a motion to sign the acknowledgement of addition of land, of the Helms land to the Tinicum Township
I'll make that motion.
Ag Security.
I'll second.
All in favor?
And I've got all those for the board to sign at the end. And in addition, we have the Vigera sewer O&M agreement to sign, but you've already acted on that, so that doesn't take any action. So I've got a pile of things to sign at the end of the meeting.
Going back to Hank and Van Leuven,
And moving it.
we do have a presentation.
You get the same 5 minutes that Rick Savetta got.
I can try to do that. We can try to do that. Thank you. John Van Leuven from East Turner Gray, representing Mark Hankin and Mark Hankin and his son Alexander Hankin. We're here because I had learned through Steve that there was some objection or some thinking on the part of the board that there was no reason to consider the First Amendment that we had requested. We started this process, Steve and I have been talking about this for about 4 years now, because we were watching the approach. We had some question as to whether or not the 25-year period was extended by moratoria. That all of those are really moot. The reason we approached and asked for the extension is we thought it was the easiest way, frankly, and the most straightforward way to resolve a lot of issues that may arise in the future. If Steve's summary in the email that he sent me is accurate, I know I don't have a problem with this board, but we know that municipal boards change, and that frankly is the reason for my appearance and for Steve's appearance. Steve was prepared to give you a lengthy history.
Mark.
Mark, I'm sorry, looking at Mark and saying Steve, I apologize. Mark has prepared a short history of this development. I know he would like to do that. I don't know how much time you have.
We certainly don't delay your meeting anymore because it's.
All right. All right, then let me just proceed. All right. The primary issue that we focused on was the modification of the impervious surface ratios in the two zoning districts that impact or in which this project was developed. There's no question the plans are recorded. Final plans have been approved for all of the sections of the development. However, there is a lot of language in paragraph 9 about applicable township ordinances. There's also a language in a couple of other sections that create ambiguities in my view for the township. When I approached Steve asking about the ability to extend, just simply extend the applicable township ordinance provisions, and Steve appropriately raised some other issues with me. He knew at the time we had gone through the process of amending of a new NPDES permit with the federal, with the state. And that took a lot of time, took a lot of review by the township. And I know there were some ambiguity. Steve and I both have the same concern about how DEP is ever going to think about enforcing this amended fill kind of stormwater management. You may or may not know, if you haven't memorized the stipulation, I wouldn't expect that you would have, but this is the 1996 stipulation that we're talking about. On stormwater, for example, Township tied its hands in paragraph 14 because it says that the parties agree that the stormwater drainage controls for the development shall be consistent with those set forth on the stormwater management report dated November 1, 1995, prepared by Showalter. That doesn't disappear. That's not an ordinance. That's a report. So Steve came back to me and he said, well, would you agree, or would Mark agree to enter into agreements with us that would require certain types of stormwater management controls consistent with the 2018 NPDES permit, and agree that any amendments, NPDES permits run for 5 years ordinarily. They're not automatically reviewed. They're often renewed. They're often renewed if the regulations haven't changed in intervening years, but they do change. They changed in 2013, and that had an impact on a lot of developments. But as I read the stipulation, the township would be an outsider, a bystander to, in that case, because your hands were tied by the stormwater management report. The NPDES is what's forcing the development to update its stormwater management controls. So Mr. Hankins said, sure. And we've worked for a couple of years, I think, trying to finalize language that we could record on the stormwater aspect. So they consider one of the considerations that's recited in our First Amendment is Mr. Hankins' ability or willingness to record these documents. The second thing that I wanted to point out, because I think it's a misconception, we all know that this or project, or at least anyone who's spent any time on it knows that this project was approved way back in 1997. The stipulation was 96. Under Ordinance 103, that was an ordinance that the township adopted to create greater open space. The consideration or the trade-off was that the developer got to reduce the lot sizes below those that were permitted in the 2 zoning districts that were impacted by the Hankin Farms. That creates a potential issue. Now those 2 ordinances have been amended to reduce the stormwater from 20% to 15%, and one of the impervious surface, which affects stormwater, but yes, Mark is correct. The impervious surface. There's another provision in here that I think sometimes has been overlooked, but I think it's important. The township's hands are tied as far as although it says that after 25 years, Mr. Hankins' developments would be subject to intervening ordinance changes, and they have to comply with new ordinances. There's another section that says, and I'm just going to read the paragraph because it gets lost. It's on page 16 for anybody that wants to go back and take a look at it. Township further agrees that no future ordinance, rule, regulation, order, action, or inaction by or of the township shall be applied to Hankin to the extent that it restricts or adversely affects beyond the applicable township ordinances Hankin's ability to construct improvements on any of the lots or open space plan as shown on the preliminary plan or as contemplated by this agreement or as permitted under applicable township ordinances. That strikes me. Unless we just all agree that we're going to extend this thing, that's litigation waiting to happen in the event anybody takes the position, for example, that you're subject to the intervening ordinances and you now have to reduce the permitted impervious surface. First of all, there's a requirement in here that the lots be improved with the houses as shown on the plan. We've done studies. We know that there are some lots that are unbuildable if the impervious surface was reduced as it's currently set up on the ordinances today. So we clean that up, we get rid of it. We just extend. We give the township some benefits with regard to stormwater control that I don't think they have under the existing ordinance. Mr. Hankin gets to continue with his development under current state and federal stormwater management regulations, updated to today. And that's really the only effect. These plans have already been recorded. I think it's reasonably simple. I think the agreements that Steve requested, frankly, with regard to stormwater are very beneficial to the township, and they don't hurt the ability to develop the project. They may be a little more expensive than it would have been under the old show water plan, but we're going to have to do it anyway. We have to comply with the NPDES requirements. So and the other thing I wanted to point out is the Ordinance 103 does not have an impervious surface requirement for lots. It doesn't say 2015. What 103 said is that unless there's a specific requirement in 103 that is set forth there, otherwise you go back to the underlying township zoning ordinance requirements from the 1993 ordinance. And that's where the 20% and the 15% came from. They didn't come from Ordinance 103. Yes, they're on the plan, but the fact that they're on the plan doesn't mean that they don't change. I mean, I think Steve would tell you that. It doesn't mean we'd argue we have a vested right to continue, but there are circumstances where those vested rights don't apply. We'd get into an argument over what the stipulation settlement agreement means. I don't think there should be a reason to do that. And that's why I think it makes sense to do the First Amendment and to do the agreements that Steve has asked us to do in consideration of the approval of the First Amendment.
Mr. Van Luvenay,
Yes.
you had mentioned the paragraph on page 16.
Yep.
If your interpretation of that paragraph is accurate, what would be the point of the paragraph that includes the 25-year term regarding the application of applicable township ordinances?
You could argue that, and I've made that comment, that I think even if you don't extend it, if we get into a fight, I think we can win under the other part. There's actually two places where there are similar paragraphs that say that you can't adversely affect the right to do that. Steve didn't negotiate the agreement. I didn't negotiate the agreement. Mr. Sugarman was there for the township. He's deceased. He can't tell you what he was thinking about. I know Mark's told me stories about writing this ordinance on it by hand and typing it up and or not the stipulation. I just don't want to have to litigate that. There's a lot of issues in here that I don't think you should want to litigate or that we should want to litigate.
But what would be the point of the paragraph with the 25-year term, the one that expired in 2021?
I'm just telling you that that's why I said it's ambiguous, because I think we get the benefit of the provisions that help us. There are a lot of exceptions that said, notwithstanding that, you can't do anything that affects the ability to restricts our ability to do what we can do under the applicable ordinance. I don't know what that means. I agree with you. It's ambiguous. And we know ambiguity is litigation. And there's no reason to do that. Mark's been with this development now for 25 years, maybe another 20 years before he finishes. He hasn't been in a rush to keep you from changing your ordinances. I think it's a fine development. Whether current board likes the smaller lots, that's what the township asked him to do. He had no intention of ever developing this farm. He only wanted Tenemer Road moved. Then he wanted to develop it for 5-acre lots. He had a plan for 5-acre lots. The township had just enacted Ordinance 103, came to him and said, would you do 103? Preserve more open space, do Ordinance 103. He did. He did his revised plan. You may not like the size of the lots now, but that's what was asked. And there was a quid pro quo, and there was a lot of consideration given, a lot of open space created as a result of the ordinance. And it's certainly by reducing, these are smaller lots, and yet the plan showed big houses on the smaller lots. They're not small, but I mean, some of them are close to an acre, not much over an acre. And that's when you take 5% additional impervious surface away on a lot of that size, it becomes much more difficult to do what is shown on the plan. And our studies indicate that we may not be able to. And if that were the case, and if not this board, but the future board said, hey, you're bound by the new restrictions, we end up in a piece of litigation over, does this restrict his ability to do what's required? Because a stipulation stays around forever. It's not gonna be terminated. I think you may have seen the provision that says, with respect to Mark's residence, they call it the residence lots. Applicable township ordinances apply for 100 years. So this thing is gonna be around. We have to live with it. And it just seems to me that it's simple to do what we've been discussing doing for the last 3 or 4 years. Yes,
Before
sir.
I ask Steve what his thoughts are on what you had just presented, I just
Sure.
want to be sure I understand. It's two issues that you're talking about. One is the stormwater, the other is impervious. Is that correct?
Well, any ordinance issue could become an issue. I mean, I can't tell you how you change them and how you
So
apply
right
them.
now, the two issues.
Those are the two that I think are
stormwater
critical.
and impervious.
We asked to extend we know that there's been a change in the impervious surface regulations and
Mhm.
percentages in these two
It's currently
districts.
15%.
In the, I
for your-
forget which,
for your
in the
property.
RA district of 20 reduced to 15, 15 to 10. Yep,
So that's the current ordinance is down to 10. Is that correct?
that's right.
Okay,
yeah.
but let's get back to the stormwater for a moment.
Right.
Regardless of whether we agree to the stormwater changes that you want to make, you're going to have to make those changes because that's regulated by the state.
We're going to do NPDES. Yes, correct.
It's regulated by the state.
We
regardless
understand
of
that.
what
yeah.
we do.
We understand that.
So really the only issue, if I understand it correctly right now, is the impervious.
That's true to an extent, except that we've been asked to do other things that we may or may not have to do. We can comply.
My concern,
Go ahead.
the stormwater word, the Department of Environmental Protection has created this thing called amended soils. Because, I don't think that many soils, especially in Tinicum Township, but around the state, can comply with the regulations. So they provide for amended soils, which are more absorptive of stormwater in order to be able to meet the stormwater requirements. One of the things about amended soils is you can't compact them. Because the minute you compact them,
Yeah, it
you
runs them.
you lose the advantage of the amended soils. So I drafted a stormwater operation and maintenance agreement and what I'll call master unilateral declaration of restrictions and covenants, and then individual restrictions and covenants for each of the lots that requires the lot owner to preserve the area, to preserve the lot from being compacted. And if the homeowner does some activity on the lot that results in the soils being compacted, the amended soils being compacted, then they're obligated to restore those soils by, whatever aeration, et cetera, et cetera. So what the three documents that I prepared do you're right in the sense that yes, they have to file the NPDES permit, but that doesn't protect, in my opinion, the amended soils. So the agreements that I prepared do that.
Protects it, assuming, of course, that there's some sort of enforcement action or some investigative action of people that are looking at these soils to see that in fact they're not compacted and they remain amended. soils.
And the trigger is if they ask for a permit to put on a deck, they ask for.
That's when that would trigger that.
That's when it triggered, because you're right.
Yeah.
The township's not gonna have somebody running around to see whether or not, somebody has walked up and down 400 times and compacted something.
Got it. Let's get back down to the impervious, at least for me. Jim and I want to have other questions. I'm certain the audience does too. So the concern is we have 15 currently, right? That you're working with 15?
We have 20 and 15. Yeah.
Okay, let's just use 15 for the moment. And then our current ordinances reduce it down to 10. Is that correct?
Yes.
So what would happen in that case? Kind of walk me through what would happen if it gets reduced.
Well, first of all, if you look, the stipulation says that nothing's going to be adverse or can adversely affect the right to do or restrict the right to develop and build the houses as shown on the plan.
Right.
So we've had preliminary evaluations by our engineers saying, okay, can we build this at 10%, for example, rather than 15? And the answer in some cases is no. In some cases we can. But it also talks about houses of the size shown on the plan. It doesn't say we have to reduce the house sizes. And those were typical, but nevertheless, that language is in here. So
So what you're saying.
so we can try to design it. In some lots, we may not have an issue. Other lots, we know we have an issue. We know we have a controversy. We make an application for the permit. The township says you enforce the 10% rather than the 15. Now, if ordinance 103 said 20 and 15 for the districts, that wouldn't be an issue, but it doesn't say that. It says it's the underlying ordinance that was in effect in 1993 that governs. That's what it says. That's what it says. But
And it also said for 25 years.
no, no, that it,
That's all I'm trying to do.
I
I'm
know,
not-
I
I'm not
know,
saying
I
you're wrong
understand
or
that.
Just
But
trying to
you're
understand.
making my point for me.
Yeah.
Think about how many times you may want to litigate with us, we may want to litigate with you, and the question is, what are we litigating over?
Well, that's what I'm trying to
I mean,
find out.
So that 25-year period expired in March of 2021.
That's correct.
So for me, the big question is, Steve, why are you drafting these documents now in 23?
Well, we
Do you-
did.
Is
We
there a
drafted 'em.
permit
Well,
application
actually,
that's
We
pending?
drafted them in 20 or 19, 20, 21.
Yeah.
I've been on the board since the beginning of 22, and this didn't pop up until maybe March of this year,
No,
June
no,
of
no,
this
no, no.
year.
No, no, no.
It didn't come up before then.
This came up before the 25 years expired. And this discussion occurred, and the documents that I drafted were drafted before the 25 years expired. And then it sat.
We had
And now it's come back after the 25 years. But I didn't draft any documents after the 25 years that expired. Those were all done before.
And what was the reason for the delay? And I'm just trying to understand it. Because Steve is correct. I
Well, I
recall, but
agree.
I'm-
There's no question. We all drafted through before
Yeah.
that and
It
during.
was a while ago.
Yeah, and we still had issues on our side.
Oh, you still had issues.
We weren't satisfied with Steve's drafts in 2021 or 2022, whenever. And we had to go figure out what lots applied. There was a lot of technical work. I mean, I have a file. I was working on this thing for the whole time, notwithstanding that we had that the period expired. It only because it struck me as it still does, that it just it's logical. It makes sense and nobody's hurt by it. That's the.
I tell you, I'd like to hear what the public has to say. I know
Sure.
you're from residents in Rolling Hills, but go ahead, I'm sorry, go ahead.
If I can add one thing.
Yeah, please.
Because I think, part of the question was stormwater.
Yeah.
And in 2020, we had a study prepared by Showalter and Associates. And just reading the executive summary, says the purpose of this analysis is to demonstrate that with respect to stormwater, permitting the development of the remaining lots at Rolling Hills Farm on 15 impervious surface ratio for the remaining RA lots and 20% impervious surface ratio for the remaining CR lots will not have any adverse impacts from a stormwater standpoint. In addition, this analysis will demonstrate that permitting the undeveloped lots to be developed with a higher maximum impervious surface ratios permitted by the applicable township ordinance will have a positive impact on groundwater recharge. In fact, what it means is because of the way the lots have to be developed under the NPDES permit and township ordinances that happen, more water will be captured and put back into the ground to recharge the drinking water in the township. Thus, undisturbed, more water will run off. We actually reduce the stormwater runoff by keeping it under the current township, under what were the prior township.
This is a very
50%,
unusual,
20%.
this was also a very unusual NPDES permit because these were all approved lots. Showalter analyzed every single lot. Every single lot has a certain percentage of lot that is permitted to be impervious. It has a certain amount of amended soils. In some cases, there's the ability to add to the original house if somebody wanted to come in to add to it. But it's all detailed in the NPDES permit and in the stormwater report, which I know the township had a copy of because we did have input during the process from the township without question, all the way through the NPDES permitting process.
All right, let's get through some of the public. You have had your hand up for a while.
Good evening, everybody. Maria Polvatz. I'm a resident of Lot 36 in Rolling Hills. I moved in the township in September 2019. And we built what is known as a Platinum LEED certified off the grid solar panel. Thank you so much for passing the zoning ordinance on the solar panels. Green, environmentally friendly house. I would like to let the board know that we are the only lot in this community that went through the DEP application permit process and has obtained, and we have an active NPDES permit. So we would like to ask respectfully the board that if you consider passing a motion and signing a unilateral agreement, our lot be excluded. And if there are any documents that are recorded with the Bucks County Recorder of Deeds, similarly, our lot be excluded for this reason. We have our own permit and therefore are bound by our own permit requirements. That permit is still active. That permit was obtained at a cost of approximately $20,000. And again, we're the only resident that had to go through this process. It was a very painful and sad experience. With that being said, and to the point that Mrs. Breslin made earlier, we purchased a lot with the understanding that the initial original stipulated settlement agreement had it as an extinguishment date, and that date was 2021. And so we were attracted by the lot because of the lack of development, open space. And with that in mind and other factors in mind, we purchased the particular lot that we now call our home. And last but not least, a topic related to the development being under construction for two decades, close to 3 decades now.
Mm-hmm.
We live on a street that is unmarked, open to the public, which is not dedicated to the township. Our driver's license, our voter's registration are issued to a PO box. We cannot engage in any interstate commerce. We don't get FedEx boxes. We don't get Amazon boxes. We cannot be found by a truck. And I had to call specifically the emergency services, police, fire, ambulance, to make sure that they have us on a mapping. They can get to us should we place a 911 call. So we would request that at least the street be marked. It's called Fox Run Lane. And potentially, if possible, some exception be granted so our street or a portion of our street can be dedicated so we can engage in interstate commerce. Last but not least, because this planned community was formed prior to the Planned Community Act, we, the residents in this homeowners association, are in the minority. We have a single vote for every lot, but because we're not in the majority, we really don't have any control as homeowners, the true homeowners, over any decisions, any amendments, anything. Thank you so much.
Thank you.
Just, with just one point, and I've been in correspondence with that woman. Lot 36 is not the subject of any of those agreements.
Thank you,
It's
Steve. That was the
specifically-
point I
it's
was going to make.
specifically exempt,
Okay.
We've,
because they have their own NPDES permit. This only applies to
I think there were some others. in the-
unbuilt lots.
Kelly Kendall, resident of Rolling Hills. So when I hear 10% impervious surfaces, I'm a little nervous because number one, that doesn't mean a smaller home. I've had my home for sale for 2.5 years. It has not sold. And it's basically because of the entire HOA. So I don't want smaller homes. My market rate is going to plummet. So
So what you're saying is you're in favor of extending the agreement that they
the
have?
15%.
Correct.
Yes,
Got it.
correct. Thank you.
I guess a question for you guys, how many lots, if you said you did a study on how many lots that would affect with regards to like not being able to build if that was reduced, how many lots is that?
I can't tell you that. I didn't go back that far. We did that a long time ago when we were starting with the NPDES permit to figure out what was going on and how we were going to do it, what design criteria we were going to use. But to Mrs. Povach's point, though, effectively, we've already got an individual permit. The NPDES permit covers lots, but each one of them has individual criteria, which is not common. We had to do every single individual lot, do infiltration testing, size the amended soils to the extent that there wasn't sufficient surface detention available in the development that had already been developed. Had to go back and redo it, retrofit the projects and the lots, so.
If I can address question.
Yeah, but you gotta go into the mic. So, sorry before, we didn't have you do that.
I'm an old man, body parts don't work, well, I apologize. The question that you raised about the 25-year term, it does, the applicability of the applicable township ordinances expires at the end of 25 years, subject to certain conditions. One of the conditions is that at the end of the 25-year term shall not prohibit the construction of homes on each of the lots or permitted architectural recreational uses on open space land contemplated under this agreement. That's number one. Number two, next page. Yeah, and Mr. Harris, I'm doing the same thing you did. Mr. Van Louvenet read that said that further agrees that no future ordinance shall basically impact our ability to develop the property as contemplated under the approved plans and the agreement. So yes, the applicability of the township ordinances may expire, but we still have the right to develop the plans, the homes in accordance with the plans that were approved. So it effectively extends it. So what we're just trying to do is make sure that we don't have disputes. And if I can just go back briefly, because you know, there is a long history here. We never wanted to develop property. In 1983, before Bruce Wallace and the new board took over, I came to the township and asked if we could relocate Teddimer Road at our cost on our property to eliminate a number of hazards. One, a very steep slope. Two, the area where the barn where we took our horses out to go riding was 10 feet from the road. The then outgoing board approved the agreement. We signed an agreement. The new board came in at the very next meeting, reversed the position, and we had a long legal battle. All I wanted to do was relocate the road. Ultimately, I determined the only way that I was going to do that was to go through a subdivision process. So I figured we'd subdivide it. It wouldn't take long. We'd submit it and get approved, and we'd relocate the road, and we were done. But the new board was very litigious. Mr. Sugarman was very litigious. We spent about $1.5 million fighting with the township. Ultimately, we won. And then at the end, the township said, okay, you can build your 75 lots, I think that's was 72 lots, 5+ acre lots. But would you instead build these smaller lots and leave more open space? Because we have this new ordinance and we, the township, would like you to do that, and we'll agree not to fight with you. And that's what we agreed to, and that's why we have this subdivision. And I don't think there is a conflict, because it says even if the applicable township ordinance provision expires, we still have the right to develop as shown on the final approved plans. So there's not really a conflict there. And I apologize.
By the same token, though, to Mrs. to Mrs. Kelly's, Mrs. Kelly, is that right? Yeah. Mrs. Kelly's point. There's a point at which, you know, litigation gets expensive. And so we have one lot. Maybe if we reduce the house size a little bit more, we can get it in without a fight. Sometimes it's going to be worth the fight, obviously, but we're concerned about the same issue that Mrs. Kelly raised with you, and that's the preservation of the house values there. I think it would be fair to say Mr. Hankin will no doubt take the position that if I can't do what the plan showed because of the reduction in impervious surface, and the township tries to force me to do that, I'm going to take the position that I have the right to do it under the stipulation, whether it's logical or not. Well, we have the right to do it. And I think that litigation, I think we'd be successful because the ambiguities probably in this case, because there's so many of them and they all tend to lean in our direction, I think we'd prevail. But Mark doesn't have any desire to litigate. He's already spent enough money with this. I mean, it's just not, but we don't think we should have to be there. We think we're benefiting the existing homeowners by not even raising the possibility that the lot sizes are going to have to be reduced and the house sizes are going to have to be reduced. Lot sizes don't have to be reduced. They're approved. It's simply a question of being able to develop without a hassle.
I suspect that the board is not in a position to make a decision tonight that I want to consider it. But just so that the board has in front of it what you're proposing is that if the township is willing to enter into the First Amendment to the stipulated settlement agreement, then Mark is prepared to enter into the stormwater operation and maintenance agreement and the unilateral declarations. and all
That's
that.
correct. Do you have copies of the current First Amendment in the form that we've approved?
I think Steve sent us copies of it.
I thought, I sent it to Terry, so I thought you probably did, but I have extra copies tonight if you'd like. it.
Curious about your copy of the stipulated settlement agreement. The copy that I have has some markups in it. Do you have a clean copy?
Well, I gave you.
We have a clean copy, but that the signed copy is the only.
Well,
Yeah.
I have a clean copy and
Okay.
They're very hard to find.
I believe I emailed you
Okay.
a clean
Because
copy, and if I didn't, you'll have a clean copy first thing tomorrow.
Yeah, I
Great.
think there is one, but we didn't
Okay.
have it either. We had, all we had was markup. I think the township may have had a clean copy. There is one recorded too, so that's probably the best place to
Well,
get the clean.
I've got a clean,
Good.
and I don't remember now where it came from because
Yeah.
okay.
We would have to get from the recorder's office, but my copy has all the signatures. Yours probably had all the signatures though, didn't it?
It has notes in the margin, words crossed out. It's not.
Oh, you don't have the final one then, because the final one doesn't have any crossouts. Okay.
I guess, to reiterate Steve's position, yeah, we'll review this, take some time, potentially put it on to the next meeting and,
That's all we're asking. We're not asking you to, I didn't expect you to say anything today.
Here's, if you ever need one, here's a clean copy.
We have-
All
we-
the signed,
we have it.
all signed,
We
all
have-
notarized. I'm sure I sent it to you, but I will check and resend it.
We can
if I
make a
did.
copy from you.
This one,
Okay.
I have to clean it back to the office. This one I do this way is my work copy because it's easier to keep it in one piece, but that's,
Well, while you were signing all those papers that I talked about earlier, I'll get Terry to make a copy.
Sounds good.
Does anyone else have a final comment before we move on? I saw some hands eventually back there.
two issues on my email too. Oh, you got somebody else wants? to
It just,
If I may, and I just forgive my ignorance, I just don't know if there was a house size that was stipulated when the original agreement was made and when the plans were recorded with the Bucks County Recorder of Deeds, and if so, what was the square footage of that house? Was it specific to a lot? Was it different based on each lot? And the reason I'm asking this question is because as you're presenting the material here, and as I'm a little bit familiar with that stipulated settlement agreement, it strikes me as 72 lots were recorded, the development was recorded as a planned development, and houses were plotted on each lot under the existing guidance, right? But what was that lot size? And what was the house size associated with each approved lot as recorded? Would that house size be impacted by a zoning ordinance? And I don't know if we can provide that answer, but
Maybe
that's my
Mr.
question.
Van Leuven can align that.
Right.
Well, there are no house size stipulated. There are always references to as shown on the plan. That's the reference. But there are other controls. I mean, there are homeowners association controls they're outside of the township approval.
yeah, basically your plan shows square footage of footprint of
The
house.
footprint, it showed a footprint and a driveway typical, but each one had one,
Yeah.
and that's,
Yeah, and that square footage could, be built 3-story house, 2-story house, 1.5-story house.
Well, I think
That
if
all
somebody
good.
wants to, I guess maybe one can comment.
I don't have the page number, but in our HOA documents, it does say minimum 4,000 square foot house.
What's that? I'm sorry, a minimum? of-
Minimum 4,000 square foot home. Now, I know there is a home in the neighborhood that is not 4,000 square feet.
And that home was an exception in writing.
I'm just making a statement. Thank you.
The reason I asked the question is for that reason, right? Because if there was an exception once and that house could be built and approved and permitted by the township, that what would prevent it?
So the only, so The only thing you gotta understand here, there's a difference between the lots and the HOA. If there's an HOA,
That's right.
those rules are the HOAs. They have nothing to do
Our
with the
HOAs
township.
matters, but nothing on the
Yeah.
plan, which was my point.
Yeah.
The plan does not stipulate house size, nor do the approval documents from the township, which is, I mean, you have criteria for building coverage, things like that. There are zoning criteria that
Yes.
were
yeah.
not waived, obviously.
HOAs, separate from township zoning ordinance, as long as they all apply to the zoning in the area.
And very briefly, I had asked for two different issues. The second issue is not as complicated as the first. There is what we call the Christopher Young property. I think you read or reviewed the access and underground utility easement. And we had put a provision in there that if Mr. Hankin and his wife or his heirs were not happy with the people who may repurchase the house from the current owners, that they would have the right to terminate the access and utility easement. That would force the property owner to go back and resort to the zoning hearing board's decision that recognized the right to use the easement, but the township's objection obviously was, what about emergency services, etc. I've told Mr. Harris is I haven't taken liberty to revise the agreement to reflect this yet, but I have told him that Mr. Hankin is prepared to grant the township and any emergency services providers perpetual right to use the easement, regardless of whether it is terminated as to the property owner. In other words, the township would always have the right to use the access easement. There are reasons for that, Mark. I don't know if your plan is close by, but the access and utility easement is down the Hankins driveway, right past their house, their barns, etc. We are more than happy to grant the township. And my problem as a draftsman was trying to figure out how I include all emergency services providers, but I think Steve and I can probably figure that out if that's acceptable to you. Our feeling is the only person that probably gets hurt by that is the existing property owner when they try to sell the property if the election is made to terminate the easement. But that's going to be the issue. But that's something that Mr. Young and Mr. and Mrs. Young are willing to accept in the document, because they're not going to make Mark angry, I don't believe. But I think if you see where this goes, you'll have a better understanding of why he feels it's important.
Our concern is if there's some future owner that is not a good citizen, meaning that they start racing up and down the driveway, or they have children who run motorcycles up and down the driveway. Right now,
I have the market, you can see it.
let me find myself right here. This is where we live. This is our house. This is our stables. This is our barn. And this is the driveway coming into our property. We're granting an easement for an existing stone driveway that goes right up the hill to the Young property. So they're going right between where we have our horses, where we have our other domestic animals, emus, alpacas, ducks, geese, etc. So they're riding right through the area where our animals are. If the people who might buy it in the future from the Youngs are not well-behaved people and they start racing vehicles up and down, that's going to disturb us if we're still alive, or my children if they're living there. So therefore, we have the ability to say, you don't behave, then you lose this, and you have to come up from headquarters road. And subject to the planning committee, the zoning hearing board restrictions that requires that they pave it and they put barriers, etc. But the township will always have the right to use this, or if Shoal Farm Road is ever continued, then they just have their easement from here. And we've given two easements, two options for easements. One comes off of the existing Shoal Farm Road, comes along the property line here. This is the original one that's going to be used.
But this road is not developed yet. That's
correct.
that's why we're talking about a much more, we'll call it an invasive type of an easement.
Now, Steve, I guess I have a question. I think we've talked about this a little bit. Say this house gets built, this property is built, the easement is granted, new people buy it, there becomes an issue, easement is removed, and do we have some obligation that we approve such a thing without having the ability to have, because I guess the
Well,
challenge that
problem
comes
is
in
the-
would be
The
like,
problem is they have the ability. They have a zoning decision
to
that
put that
says
drop
they
line.
can come up that steep hill.
Okay.
Oh, this all started because in the beginning, the first time that the Youngs approached the township for a permit, the township said, well, A, I don't think we can get our inspectors up there. B, I know you can't get an emergency vehicle up there. As a matter of fact, I think whatever entity services that area said, we can't get up there. And the township said, and we said, hold it, we're reluctant to issue a permit because we don't think people are going to be able to get up there. That then led, as I understand it, to the discussions between Mike and the Youngs as to having an access easement.
Yes.
And that was the first entity. And I said, well, that's all very nice, but now we got to get utilities in there too, because you don't want to tear up that steep bank by putting utility easements in. So the next variation was an access and utility easement. And that was what was being considered. And then at the end, this issue of termination came up. And I wrote back and said, well, that's crazy.
Yeah, I did have a provision. I did have a provision in the one that you reviewed. That said that the termination of the easements pursuant to this paragraph shall not preclude the use of the easements by emergency vehicles, including fire and ambulance, or by governmental personnel and vehicles as a means of access to the grantee's property. Now, technically, I believe that it would be an improvement on that to expressly grant to the township as co-grantees that right. And however we decide to describe the other co-grantees, because that is not an issue with Mark. I mean,
let me just ask, and I don't, believe me, I don't intend to get ahead of what the board's feeling, thinking is, but if Shell Road were built, that easement would not terminate.
This easement will not terminate, correct. That's perpetual.
Well, but that's my point. Right now, the provision is that the whole easement is terminated. One thing.
Yes, we would just be talking about the portion.
well, and I think, Steve, I think
there
there is an exhibit D that I don't think was attached that would cover that. If there is a reference to it. I mean, you and I worked primarily on the wording, and now we got to this, and that's fine tuning, but the grantor should amend it at such times the Shell Farm Road is extended as shown on attachment D to terminate the easement over the access easement area and its place grant an easement over the portion of the driveway labeled as exhibit D, future easement area. That is all in the draft. It's just that we didn't have this plan attached. You and I were working on the language, not so much the detail, but that is in there.
I guess my other question related to that would be, okay, say you terminate the agreement with whoever lives there and you're granting emergency vehicle access. Who's maintaining that access for the time that that potential homeowner is not using it for their access to their house? But now we have.
There's no maintenance obligation being imposed.
No,
I
think
I'm saying
Jim's
some
concern
You
is
still have the right, you have the ability to use it.
if
Well,
you've
it
got
ha-
the ability to use it, but it's not being maintained. And
that ability for a fire truck ends up in the mud. Basically,
I have no problem making that a right to continue to maintain. I've been maintaining it for the 45 plus years I've lived here.
just I know we don't necessarily have an obligation for something like that, but if we're
Would you make it enforceable by the township?
Yeah,
You did,
absolutely.
but make it enforceable by the township so that you could force the property owner to maintain, not trying to impose any expense on the township or the emergency services.
okay. We do have a public comment.
You have to go up to the microphone.
Shoal Road is indeed paved and does exist, and it is an open road undedicated, so therefore unmaintained by the township. We access our property. We're all the way at the top of the hill, so we have to drive over that steep hill and then access our property immediately after we pass the infamous mulch pile that resides at the end of the Shoal Road as a decoration.
So Shoal Road is in place?
Shoal Farm is very much a paved road.
And it's
Right.
It is dedicated.
It is not dedicated, and Mr. Harris can just provide clarity on that. If it would have been dedicated, it would have been dedicated. My understanding and looking at the mapping, the road is dedicated up to 6 Shoal Farm. And from that point forward, in the phase 3 of the development, the road is not dedicated. There's a house that's there for sale that is on the undedicated road. And our property, which is off of Fox Run, which is towards the end of that Shoal Farm, is similarly on a undedicated road. So Fox Run goes all the way to the cul-de-sac and turns back down to Shoal Farm, down the hill. Right? So I want to make the point, and go ahead, Mr. Rosenau.
But the road that we were talking about has to do with an easement. Is that paved? That's my question. That road does not. Okay, that road doesn't exist. Okay, thank you. Correct.
Where does it currently stop on?
It stops right at that.
Right at,
wide-
right at the intersection. Okay.
And this from Shoal Farm Road is dedicated as is Fox Run Road. They're both dedicated to the township.
Yeah, that's what I wanted clarification.
That road is not paved, it's just a stone road. And I think last year or the year before that, there was stone placed on it, so it's being maintained. My question was not in relationship to this road. My question was in relationship to Shoal Farm, and I wanted to make the statement that the road is very much paved. It's undedicated, and we need that road to access our property. That's the point I was trying to make. Thank you.
Again, I want to be clear, Mark.
Go ahead.
The road that I'm talking about is the Shoal Farm Road that we're talking from the Y over to where that easement is.
That's what we thought. Yeah.
Is there gravel on that? Is that a road?
no,
Is that
no,
accessible
no.
by a car or something
No,
like that?
that is not. This is
Thank you.
stone,
That's what I want.
and the secondary alternative is shown in, I guess, it's brown, is also stone. Because we maintain this so that we can get over to the community and we can get our equipment. We
So-
cut the common open
So the
space.
red portion is colored red there, that's in place?
This is stone and in place.
So why wouldn't then somebody access their property, the Youngs, I think is the name,
Yes.
correct? Why wouldn't they access it then from that stone road there?
Because at some point in time, this road will be extended.
Mhm.
And when that does happen, there'll be construction going on here and they won't be able to get there. That's why with a better driveway is coming straight up here. If for some reason we decided that we wanted to terminate that with the Youngs, we showed this and we discussed with Steve. We have a second alternative, which is this one here.
Could that be part of the agreement that
As a
they're asking
secondary
for-
one?
As a secondary?
You
one?
know whether
In
it
case-
adversely affects the ability to develop these lots,
case
so that's
they-
what I don't know.
It-
That's,
In case you say they're abusive, not the Youngs, but anybody is abusive, and you can't use our easement any longer, can they then go to that easement that you just pointed out?
They could until the time that this portion of the development would be open. Because then these become other people's lots. It's their backyard. This road would disappear.
Okay, so they'd have to wait then until the continuation of Shoal Farm Road, the white section there with the cul-de-sac at
Yes,
the
sir.
end is in place.
Yes, sir.
unless they,
So you-
unless they improve the driveway through the easement that they have in accordance with the zoning hearing board decision.
So the pale green sections just below the road that doesn't exist yet. Yeah,
Yes, sir.
just that area.
So this is
Those-
open space.
Okay, and it will always be.
Yes, ma'am.
Okay, so then why not just reorient those lots that have yet to be developed so that they face onto this orange line instead of the road on the right? If you were to make the,
That would, it really doesn't meet the side yard requirement.
No,
of a lot of other stuff.
Nothing would meet this in the approved stormwater plan, which is part of our NPDS.
Those
permit,
lots
has
are
a
covered by the
stormwater basin
NPDES.
down here. We catch all the stormwater down here. We wouldn't be able to catch it up here. This,
from the road itself, you wouldn't be able to.
correct.
Mhm.
Now, if I can correct one thing, Terry, I'm sure that you know.
I'm sorry, what?
Sorry. Shoal Farm Road was dedicated to the township up to the point that it intersects with Fox Run Road.
Yeah, let's
Fox
finish.
Run Road is also
Sorry.
dedicated. Fox Run Road is also dedicated.
I have no idea. I don't know. Could it be?
And on be dedicated if local development is complete, at which point the township will assume responsibility for maintenance over that road. As a result, the road is unmarked and undedicated, but open to the public, and has been open to the public for a very long time. It's accessible to vehicles, to pedestrian traffic, to everyone else, but it's not dedicated.
Let me say that I don't know whether it's dedicated, but that sounds like something I would say. That the township would not want that road dedicated and then have construction occurring on the lots that were on that road because they get cut up by the construction vehicles, et cetera, et cetera. So my guess is that Fox Run hasn't been dedicated yet. That's my guess.
Mr. Hankin, what makes you believe that it has been dedicated?
Simply because I remember dedicating it, the road was completed, the escrows were released.
Well, that should be easily verified.
We can figure that out
We
real
can figure
quickly.
that out, yeah.
Registered and address and have, passports issued to others and
We'll look into it and we'll have an update at the next meeting. And I guess,
We were gonna bring that up anyway, not tonight, but at another meeting, because there's a lot of old escrows sitting around and I've asked the same question, where do we stand? What was approved? What was dedicated? What isn't done? And can we clean a lot of it up? That's-
I guess based on this issue with new information, do you want to make a decision tonight or do you want to?
Oh, no, I wanna.
You want to take it?
Take another look at this.
So we will.
That's fine.
Maybe Steve and yourself tweak that easement a little bit. to
Okay.
get it-
Well,
get it
that's
clear.
what I was gonna ask. I mean, if you want, we can probably get and put all the exhibits on it so that you have a complete picture. And we'll make an effort to do that. I'll try to get that done in the next week so that you. I know that well. You can record color, but it turns black and white when you record it, so it doesn't do it.
Okay.
All right.
Thank you.
All right. Thank you.
Thank you for coming in. Thank you for coming in.
Okay, on to new business, Lower Delaware Wild and Scenic Grant Project, mini grant application. Eleanor, you have some information on that?
Yes, so the EAC has put together good night. An application for a 2024 mini grant offered by the Lower Delaware Wild and Scenic. And it is for an initiative called the Backyard Environmental Stewardship and Tinicum Initiative, the BEST initiative. And it basically is kind of a 3-component community-wide project to educate our residents, really of all ages, on the importance of getting rid of invasives that are in our backyards and replacing them with native plants, and kind of connecting it to why that's good for the environment and why it improves habitat. There would be 2 educational components to this, with support from both the Tinicum Conservancy and I think they're a naturalist or an educator from the DCNR. Our hope is to offer this to, I think I have to put in 75 to 100 residents of the township. So it's a big initiative. It would be free for participants. They would receive a copy of a book that is published by the U.S. Fish and Wildlife Service. That is really, really a handy tool to help people identify invasives, kind of just use in their own personal spaces. So I do want to, for the board, on page 2 of this, where the table is, and it indicates the funds requested and the task and description timeline, and kind of the contributions of kind of in-kind type contributions. The chart needs to be updated. I just need to add in the estimated volunteer hours and the estimated value of those volunteer hours. But the amount that we would be requesting from the Lower Delaware Wild and Scenic is less than $1,000. And we think that this is an initiative that could have, could really have good benefits throughout our community. So I'm asking for a motion to approve, the submission of this grant application with those minor adjustments that I need to make.
Make that motion.
I'll second. All in favor?
Aye.
Aye.
Thank you, Eleanor.
Thanks.
The Haynes and Rendezvous Farm Planning modules. Steve,
When,
is this something that'll take a little bit?
10 minutes?
Let's adjust. You guys have been sitting here for a while, so. Let's,
I would like to make a motion that I come up here tomorrow and lubricate the hinges on.
Second.
all right.
Second.
All right, let's put this through because we have a zoning hearing board applicant here that needs a decision from us. This is zoning hearing board application 2023-10, Brian Doherty on 4-lane. This is the applicant request release from the floodplain regulations requiring an HVAC system installed by a previous owner without the township permit to be elevated above the base flood level. This was heard by the planning commission on 11/28. It's before us to send the solicitor or not today, and then your zoning hearing board meeting is tomorrow on 12/6. The PC reviewed this. They recommended we remain neutral with the request that the township gets a hold harmless. I guess, Steve, I would ask you if that's something that we can do, and I'm assuming that's because of equipment being installed not per.
Yeah, well, what happened was that the prior owner of the property installed an HVAC system below the regulatory flood elevation. And I think everybody agrees that there isn't any place to install it above. So they've come in and asked for a variance to have it below the regulated flood elevation. And the planning commission recommended the variance be granted, provided that there be a hold harmless agreement, holding the township harmless from any liability in the event that either somebody was hurt or damaged as a result of the thing being under the regulatory floodplain. So I drafted a hold harmless agreement and sent it off to Mary Eberly. Now, I do have a question that while I see Brian Doherty, I also see a female acquaintance. Is that a co-owner of this property? Well, I didn't want to, make any judgments, but seriously, is this property owned by you and your wife jointly?
Well, I mean, I don't know. I'm not a lawyer, but
Who's on the deed?
I am.
Okay. I'm sorry.
That's okay.
I just wanted to,
We just got married in September, so I don't.
Congratulations.
Thank you.
well, if this agreement was approved and signed by Mr. Doherty and the township and recorded, and he subsequently then transferred the property into joint names or sold it, it would be binding on whoever the future owners were. So, the way I had left it with Mary Eberly was that she would present it to you at the zoning hearing board in the event that the zoning hearing board was willing to grant you a variance.
Okay.
Now, the agreement has to be signed by you in front of a notary.
Okay.
So, if you want to take a copy of this off to and get it signed before a notary and take it with you tomorrow night, that's fine. If not, that's not a requirement of the board approving a variance if they decide to approve it.
Right,
That's their decision, not ours.
Well,
And then you
I
just
do
have
have
to-
legal representation. Stephanie Shortle is going to be with me tomorrow night. Is that sufficient, or do you want me to have it? Okay.
No, Mary Eberly will give you a copy. You'll sign it in front of the notary and bring it back here, and it'll be on the agenda the 19th to be approved by this board and recorded.
And
I
should I,
guess-
do I need to be present for that meeting or is it?
The zoning
just a-
hearing?
No, I'm gonna be there. No, I mean on the
No,
19th.
if the signed and notarized document is back in front of the township on the 19th, you do not have to be here.
Okay.
Although I can't imagine why you wouldn't want to be.
And I guess just to clarify, we don't have to make a motion, but there's no need to send anyone. because We'll maintain a neutral.
Do we have to make a motion, Steve?
No.
We're not doing anything.
Good luck.
Thank you very much. I appreciate it.
At least gave you a fun date night, right?
Yeah. How much fun.
All right, Steve, back to you. On to Haynes and Rendezvous Farm.
Yeah. When this came up, I think it was the last meeting. This is the situation where Haynes wants to file an application for a planning module. And the planning, and although they want to and have a permit, or I don't think they have a permit, they have a health department will approve a micro drip system. That's an alternative system, and they can't get the planning module approved that way. So they can only get the planning module approved by submitting it a spray irrigation system. And you at the last meeting said, hey, we ought to get a letter from them saying, we don't want to put in a spray system, we want to put in a micro system. So this is the letter, and that's what I called Scott Drumbar, who's the engineer that's handling this, and said, please get a letter that says that you'll put in a drip system, even if a spray is approved, and this is the letter that came back. So the question is whether or not this letter is satisfactory to the township. If it is, you would then process the planning module, which is what the request is.
Yep, and again, I guess basically, this request is sort of as a reminder if they were to go back on it. It's not a binding letter, but at least it gives us something to say, to go back if needed.
That's correct. I mean, basically they're saying, look, we're gonna put, and as I explained the last time, nobody in their right mind would put in a spray system if they had an alternative. And this is just saying, look, we're gonna put in a drip system unless there's absolutely no alternative, is basically the way I read it. So I think they probably.
I'll make a motion to sign the planning modules with this letter attached. That's acceptable.
Second.
All in favor?
Aye.
Aye. All right, moving on to regular business minutes. I'll make a motion to approve. Oh, sure.
So are you making a motion to sign, or are you gonna authorize someone to sign?
Doesn't the planning commission still have to sign it?
So we authorize.
I think
The planning commission?
yeah, the motion should be to process the planning module, and once the planning commission signs it, then you can send it off.
Thank you.
All right, on to regular business. I'll make a motion to approve the minutes of November 21st, 2023 as written.
I'll second.
All in favor?
Aye.
Aye. The treasurer's report and budget recap.
At the last meeting, I had given you the treasurer's report. In your packages, you have the October recap, and it's also posted.
Thank you. I'll make a motion to approve the payroll report ending 11/17 in the amount of $33,941.90. And I don't have the amount for 12/1.
$41,254.06.
That amount. Do you have a second?
I'll second.
All in favor?
Aye.
I'll make a motion to approve the distribution list as written.
With
Well,
the exception
of the
of. Thank you.
With the
The
exception.
last run.
Of
Bucks
the
County
finalization
Tax
of the,
one.
Okay.
Yeah, that was tabled.
second.
All in favor?
Aye.
And we have advertised hearing for the adoption of the 2024 budget. That was for today. I'll make a motion to approve the 2024 budget.
I'll second.
Any comments on that? All right, all in favor?
Aye.
Are you gonna tell them about the big tax increase?
Yeah, then I'm leaving. No tax increases for 2024.
You all really need to love our boards. We haven't had one since 2010. And the 2010 was to help our emergency services. So, your boards and the team here has really done its best to keep your taxes and down and still provide services. So they deserve your applause now.
Should have said that when we had a big crowd.
On to some more conditional use and zoning announcements. Conditional use application CU 2023-3 Bagheera, the conditional use decision and maintenance agreement need signature tonight.
There's no action
Yep,
needed.
we're
You need
just
to
saying-
sign it, but there's no formal action required.
We're granted that at the 10-3 meeting. We went through item 2 and 3. Item 4, the zoning hearing board application ZHB 2023-9 Paul Wien. The zoning hearing has been scheduled for 1/11. We made a decision to send the solicitor and the zoning officer on 11/21 to oppose. And that's it for that.
Well, there was a settlement proposal floated. Is anybody interested in making a motion to approve that? I hear no motion. I will provide that information back to the attorney for Mr. Dr. Williams.
Steve?
Yeah.
While you're on that subject, I don't think we announced our executive. We did not.
We had an executive session. He was gonna do it at the end, I think.
But any event, we did have an executive session from 7 to 7:30 to discuss potential litigation. Item 5, zoning hearing board application ZHB 2023-5 Mark Calloway. That is the Board of Supervisors. We made a decision. Which one was
You
this?
made a decision not to send me.
We are staying neutral on 10-3, and that zoning hearing board was held at 10-26 and it's continued to 2/8/24. And then finally, the zoning hearing board application ZHB 2023-12 Weiss and Wolf. This will be the planning commission reviewed this on, or will review this on 12/12. It'll be before us to decide to send the solicitor on 12/19, and that hearing is scheduled for 2/22.
Did you say not to send solicitor?
That's it. Decision.
Decision, just send.
Decision.
Oh, okay.
That was one that we did before. That was for the. poll
Yeah, I know
board.
that, but I thought you said not to send. That's awesome. But no, that's okay. That's fine.
Yeah. We're staying neutral on that. Public comment. Anybody want to stay longer? No. All right. Oh, we have one.
Since I don't come here very often, I just want to thank you all for the wonderful work that you've been doing, and congratulations to the new representative that will be sworn in very soon.
Yep.
I've been in your shoes before and it's tough work, and I know none of you get paid with the exception of Mr. Harris. And also thank you very much, Terry, for all the wonderful work you've been doing. You've been a blessing. You were one of the few friendly faces that I ran into, and you've made my experience in getting all of the permitting for our house 4 years ago really such a pleasant experience. So thank you so much.
Thank
Yep.
you.
Thank you for the kind words. With that, I'll make a motion to adjourn.
Second.
Okay, adjourned. Thanks, everybody.
I've got a bunch of agreements that I'm going to be passing down the line.
Mr. Harris, I'm sorry.